Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Joseph C. Jones. Decided March 17, 2026. Halligan, J. Mistakenly believing the defendant was the target of their arrest warrant, a group of parole investigators approached and then chased the defendant. During the pursuit, they observed him discard a firearm. The defendant was arrested and eventually pleaded guilty to a single count of attempted criminal possession of a weapon. We conclude that the gun, along with the other recovered evidence, should have been suppressed because there is no record support for the lower court's finding that the investigators' pursuit of the defendant was justified. Accordingly, we reverse. 1. Defendant Joseph C. Jones was indicted on 2 counts of criminal possession of a weapon in the 2nd degree and 1 count of possession of a controlled substance in the 7th degree. He moved to suppress the 2 handguns and the narcotics recovered after the arrest on the ground that the pursuit was illegal. At the suppression hearing, a Department of Corrections and Community Supervision parole investigator testified that a DOCCS apprehension team had set out to locate a parole absconder for whom they had an arrest warrant. None of the team members were personally familiar with the absconder, but they were given a document with his booking data. That information included a photo and described his height as 6'01", his weight as 180 pounds, his race and hair as black, his eyes as brown, and his skin tone as medium brown. The team interviewed the absconder's girlfriend, who suggested that he may be in a certain city block in Rochester. Nearly an hour later, the team traveled to that area. The investigator testified that he and his partner were in an unmarked vehicle and plain clothes when they observed the defendant walking from the direction of that city block. The investigator testified that he observed, from a distance of about 20 yards, that the defendant was right around 5'11", 185 to 200 pounds, and was wearing a black ski mask. He said this observation had significance because the absconder's description was 5'11", 180 pounds, 185 pounds. Because of the ski mask, the investigator was unable to identify the defendant's race, his facial features, or other identifying characteristics. The partner likewise testified that the defendant met the approximate physical description of the individual they were looking for, but did not offer anything more specific. At this point, the team was traveling in separate vehicles, with the investigator and his partner following 20 to 30 yards behind a car holding another team member. As that car pulled alongside the defendant, he began to run. Because the approaching team member did not testify at the suppression hearing, nothing in the record reflects whether that officer and the defendant interacted or exchanged any words. Supreme Court found in its suppression ruling only that a member of the team pulled alongside the defendant, at which point the defendant began to run away from the location. The investigator and his partner then exited their vehicle and chased the defendant because they thought that he was the parole absconder, although they also acknowledged that they had not observed him commit any criminal activity and that it was not a crime for him to run. In the course of the pursuit, the investigator observed the defendant discard a black handgun. Upon catching up with the defendant, the pair took him into custody and realized for the first time that he was not the absconder named in the warrant. In conducting a search incident to arrest, the investigator discovered a medicine bottle with 6 vials containing a white rock substance. He also recovered the black handgun he had seen the defendant discard, as well as a silver handgun discovered along the defendant's flight path, although neither the investigator nor his partner had seen the defendant in possession of the silver handgun. Supreme Court denied suppression, applying a rule for mistaken arrests derived from the U.S. Supreme Court's decision in Hill v. California. The court credited the testimony of the investigator and his partner and held that the defendant's physical similarities with the absconder, coupled with his immediate flight upon being approached, supported the officer's reasonable belief that the defendant was the target of their warrant. The defendant subsequently pleaded guilty to a single count of attempted criminal possession of a weapon in the second degree. The Appellate Division, 4th Department, with 2 justices dissenting, affirmed Supreme Court's suppression order. The majority rejected the defendant's argument that the encounter should have been evaluated under the framework developed in People v. DeBoer, instead applying the test set forth in Hill. As to the first element of the Hill test, whether the officer has probable cause to make an arrest, the majority observed that there was no dispute that the officers possessed a valid arrest warrant. As to the second element, the majority concluded that under the totality of the circumstances, the arresting officer's testimony established that he reasonably believed that defendant was the absconder. The defendant closely matched the height and weight provided in the parole absconder's description, covered his face with a ski mask, was in the location provided by the absconder's girlfriend, and immediately fled upon being approached by one of the team's unmarked vehicles. The dissenting justices agreed that Hill's reasonable belief test applied, but would have held that it was not satisfied. According to the dissent, the people established only that the defendant matched the generic height and weight of the average male in the general population. Notably, the pursuing officers could not see defendant's face or even discern defendant's race, given that they were 20 to 30 yards away from defendant, who was, reasonably, wearing a ski mask on a cold December day. Moreover, the people did not call the approaching officers and thus adduced no testimony with respect to their actions, observations, or whether they believed reasonably or not that defendant was the parole absconder. A dissenting justice granted the defendant leave to appeal. 2. The defendant and the people disagree about whether we should evaluate the investigator's pursuit and arrest under DeBoer or Hill. The people also argue that defendant's argument about the applicability of DeBoer is unpreserved for our review. Both the people and the defendant cited DeBoer cases in their motion papers before the suppression court. It was that court which first relied on the Hill rule. Because the defendant makes essentially the same argument before us that he made before the court of first instance, that DeBoer should control, it is preserved for our review. See CPL 470.35. The DeBoer framework lays out 4 escalating levels of law enforcement intrusion and the degree of suspicion necessary to justify each of them. At the first level, police may engage in minimally intrusive questioning when there is some objective, credible reason for that interference, not necessarily indicative of criminality. DeBoer. The second level permits a somewhat greater intrusion to the extent necessary to gain explanatory information and requires a founded suspicion that criminal activity is afoot. Once an officer entertains a reasonable suspicion that a particular person has committed, is committing, or is about to commit a felony or misdemeanor, they may stop and detain that person. Finally, at level 4, an officer may arrest a person if they have probable cause to believe that a crime has been committed. Here, the parole investigators pursued the defendant, which the parties agree requires reasonable suspicion. See People v. Cleveland, pursuit of a fleeing suspect constitutes a level 3 detention. Hill addresses the validity of a mistaken arrest. That is, when the police have probable cause to arrest a person, typically an arrest warrant, and reasonably but mistakenly believe the person arrested is the person they are seeking. United States v. Glover. The arrest of a person who is mistakenly thought to be someone else is valid if the arrest officer A has probable cause to arrest the person sought, and B reasonably believed the person arrested was the person sought, citing Hill. Each department of the Appellate Division has embraced this rule in the context of a mistaken arrest. See e.g. People v. Porter, People v. Fabian, People v. Tejada, People v. Dorch, though none appear to have contemplated the circumstances present here, namely, an arrest predicated on something that happens in the course of a pursuit and not on a warrant. We need not decide which of the tests should control, because in this scenario, we do not perceive a meaningful difference between Hill's requirement of a reasonable mistaken belief and DeBoer's Level 3 standard of reasonable suspicion. Indeed, during argument, defense counsel effectively conceded as much. Under Hill, the arresting officer must provide reasonable, articulable grounds to believe that the suspect is the intended arrestee. Sanders v. United States. See also State v. Lee. By the same token, our DeBoer case law specifies that reasonable suspicion requires an officer to point to specific and articulable facts which, along with any logical deductions, reasonably prompted the intrusion. People v. Braddern, quoting People v. Cantor. Thus, when it comes to evaluating this particular scenario, the tests essentially ask the same question: whether the totality of the circumstances, including the defendant's appearance and any additional observations about their behavior, justifies the resulting police-citizen encounter. Decisions from other state high courts applying Hill have suggested a similar convergence when a mistaken arrest occurs in the context of a street encounter. See State v. Smith, applying Hill, but observing that, in the context of this case, probable cause means cause to believe that the defendant was the person named in the warrant. State v. Sanders, citing the Hill rule, but holding that the initial stop to ascertain the defendant's identity had to be justified by reasonable suspicion. 3. Whether framed in terms of reasonable suspicion of criminal activity or reasonable mistaken belief that the defendant was the target of an arrest warrant, the record here does not justify the pursuit and subsequent arrest of the defendant. 2 reasons yield this conclusion. First, the pursuing investigator's testimony does not reveal a sufficiently close match between the defendant's appearance and the identifying details they were given about the parole absconder. Second, the defendant's flight from the investigators, on which the appellate division majority relied, cannot support an inference that he was the target of the warrant because the record is devoid of any suggestion that he could have known he was fleeing from law enforcement. A. The pursuing investigator's testimony establishes only that the defendant matched the absconder's description in a broad generic sense, which is to say that he barely matched the description at all. From a distance of 20 to 30 yards away, the investigators saw a male walking from the direction of the city block that the absconder's girlfriend had identified. He was around 5'11", weighed 185 to 200 pounds, and was wearing a black ski mask. The investigators could not identify the defendant's race or say whether he resembled the photo that they were provided. The concern is not whether the defendant's description was reasonably close to that of the absconder, but rather that those concrete details, which establish only his general build, would fit any number of people. As the dissenting justices below observed, all this testimony demonstrates is that the pursuing investigators saw, from some distance, a man of average height and build flee upon being approached by another member of their team. A review of DeBoer cases indicates that a match in such broad terms does not permit the conduct here. The appellate division has typically required an officer, acting on a suspect's description, to point to more specific identifying features to demonstrate the reasonable suspicion necessary to justify a Level 3 stop. See e.g. People v. Johnson. Officers showed a sufficiently specific match of clothing and physical characteristics. People v. Medina. Surveillance photos showing a striking strong resemblance to the defendant supplied reasonable suspicion for a stop. Likewise, numerous cases hold that although a match to a general description, even one more specific than that at issue here, may support level 1 or 2 encounters, such level of detail cannot, without more, justify more serious intrusions. See e.g. People v. Greenidge, holding that a match in general description could provide the police with cause for a level 2 encounter. People v. Abdul Mateen, match in clothing, gender, and race could warrant a level 2 encounter. People v. Smith, People v. Howard, generic description of black males carrying bags supplied the basis for a level 1 encounter. Cases from the Appellate Division and other courts applying Hill likewise require a significantly greater degree of corroboration between the mistaken arrestee and the subject of the warrant to find the requisite reasonable belief. For example, the two individuals share the same name. See e.g. Tejada, Sanders, State v. Bateman, United States v. McEachern. The mistaken arrestee is found in a specific locale that the target is known to frequent. See Hill. Or, at a minimum, there is testimony from the arresting officer that provides a good deal more specificity about identifying features apart from a suspect's generic build. See e.g. Fabian. Arrestee was the brother of the wanted individual, and a comparison of photographs revealed a reasonable likeness between the two. Dorch, arrestee mistaken for his brother by officers who testified they look alike. Indeed, a number of cases find arrests invalid despite stronger corroboration of identity than we have here. See e.g. Smith. And caution that an arrest cannot be justified in reliance on a description so general that it fits a very large group of people. Lee. See also State v. Frazier. B. The Appellate Division majority further relied on the defendant's flight upon being approached, but we do not find this a sufficient ground to support the pursuit and arrest either alone or in combination with the general match in description. For a suspect's flight to reasonably inform the officer's suspicion of criminal activity, there must be, at a minimum, some indication that the suspect knew they were fleeing from the police. After all, an individual has the right to be let alone and refuse to police inquiry. Cleveland, quoting People v. Holmes. Accordingly, we have underscored that a finding of reasonable suspicion may not rest on equivocal or innocuous behavior that is susceptible of an innocent as well as a culpable interpretation. Brannon, quoting People v. Carrasco. When it comes to the probative value of a suspect's flight, federal cases take a similar view. See e.g. United States v. Castle. In the context of a reasonable suspicion analysis, furtive gestures, like flight, are significant only if they were undertaken in response to police presence. Illinois v. Wardlow, flight supported inference of criminal activity when officers were working in uniform as part of a police caravan. Nothing in the record here demonstrates that the defendant could have known that he was fleeing from law enforcement. The pursuing investigators were in an unmarked car, and at least one was wearing a hoodie, jeans, and a vest. The attire of the partner is not described. The record does not indicate that any of the investigators, either the one that first approached the defendant or the ones that chased him, ever identified themselves as law enforcement. Perhaps this would be a different case if the record included such evidence. But because the approaching investigator did not testify, we did not know whether that officer thought the defendant was the target of the search warrant, if they exchanged any words at all, let alone what they might have been, or whether they might have identified the officer as law enforcement, or why, if the officer reasonably believed the defendant was the target of the warrant, he did not pursue him himself. The only hint in the record that there was any sort of substantive interaction with the defendant prior to his flight was a question by the prosecutor, in which he asked the investigator how far away he was from the defendant when someone from parole was speaking with him. The investigator only responded 20 yards. Absent any affirmative testimony as to what, if anything, was said to the defendant, we find this too slender a read to support the proposition that the investigator and his partner reasonably understood the defendant to have identified the approaching investigator as law enforcement and fled as a result. The appellate division majority cites two additional points, neither of which we find sufficient. First, the majority noted that the defendant was found in the general area indicated by the absconder's girlfriend. But this point does not carry much weight. Nearly an hour had elapsed, and the tip was just that he may be found in the general vicinity of a certain city block. Such a general description does not permit an inference, without more, that an individual encountered on a public street was the person sought. The majority also remarked that the defendant was wearing a ski mask, but the testimony established that the investigators did not find that unusual given the cold weather conditions. None of these factors, alone or in combination, were sufficient to justify the pursuit of the defendant. Just as New Yorkers have the right to be free from unreasonable governmental intrusion, law enforcement must also be able to execute warrants effectively and efficiently, and neither Article 1, Section 12 of our Constitution, nor the Fourth Amendment require certainty before they do so. But a warrant authorizes arrest only for the person named in the warrant, not for any person the officers may encounter who bears some passing resemblance to the suspect. Here, the record is simply insufficient to establish that the parole investigators did enough to corroborate identity before engaging in the pursuit of the defendant. Accordingly, the order of the appellate division should be reversed, the defendant's suppression motion granted, and the indictment dismissed. Order reversed. Defendant's motion to suppress granted and indictment dismissed. Opinion by Judge Halligan. Chief Judge Wilson and Judges Rivera and Troutman concur. Judge Canataro dissents and votes to affirm in an opinion, in which Judges Garcia and Singas concur. Decided March 17, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.